We are live. Good morning. This is Senate Judiciary and welcome. It is January 28th. This morning we'll be talking about Act 183, an act related to home improvement and land improvement fraud. This is simply a walkthrough, making any changes or whatever we feel necessary. And joining us this morning is Ledge Counsel. So without further ado, I guess we'll turn it over to you, Willis.
Right, for the record, Judiciary for the Office of Legislative Counsel.
Do you have another copy of the bill?
I unfortunately do not. Emery, any chance that you have an extra copy?
Good.
Should make it part of my craft. Always have an extra. You can put me an extra copy or two.
Awesome. Thank you.
So I think Michelle mentioned this in our initial walkthrough, but this bill was changed in 2015, and these new changes kind of revert back to something closer to the pre-2015 version. So the version before the 2015 changes had an intent to defraud requirement that was very clear, knowingly enters into a contract. It also had a presumption such that if a person did not complete a contract, the jury could presume that they entered into the contract with an intent to defraud. In 2015, the legislature removed the word knowingly from the phrase of the person entering into the contract. And some trial courts recently have read that as removing an intent to defraud requirement. I think the committee heard testimony that is not the way everyone reads it. But if the home improvement fraud statute did not have an intent to defraud requirement, several trial court decisions based on the United States Supreme Court precedent have found that there would be an issue with the 13th Amendment. Happy to walk through that, the trial court decisions or issues that the committee would like to kind of run through them again. But the bill would clarify the intent that intent to defraud is a requirement under the statute. So it kind of returns to something closer to what the statute was prior to 2015. But it does so kind of in line with what those trial court decisions found regarding right, a constitutional statute.
Excuse me before you go any further.
Absolutely.
My train of thought, obviously. The new proposal in S-183, it says that it require that a person knowingly intend. So are we saying that if we struck the word knowingly, that the intent would still remain, or how do they work hand in hand? What page are you on? Page 1. I'll place it to the board note that is.
So
27.
Well, that's just a statement of purpose, right? So that's not.
well, yeah, so I think one way to think about the language, if you look on page.
Well, and also I think knowing raises, not lowers the standard of proof. Yes.
So if generally, in terms of like the kind of tiers of mens rea, knowingly is a lower standard of proof than intends. But I think the language here is intent to defraud refers to like when you're entering into the contract, not when you don't complete the contract. So knowingly means that you, like without mistake, entering into the contract, do not intend to complete it in whole or in part. But I appreciate how putting knowingly and intent together is confusing. But I think the idea is intent to defraud just means at the time of contract, you not mistakenly are not planning on doing what you said you do in the contract. Does that help a little bit?
There was one too many negatives in that.
Fair enough.
The problem I'm having is
Mhm.
that I don't know, in the bill, I don't think it pairs knowingly and intent. Right?
Correct.
So I don't, it's not really an issue what the subject piece says on line 7, because that's not conforming from us.
Yeah, I think intent to defraud as a requirement is a way that trial courts have talked about what it means to require at the time of contracting that you don't intend to do the work you said you do under the contract.
But, and following up on Senator Bruce,
Mhm.
on page 2, this is where it was line 18.
Yes.
It says when the person knowingly enters into the contract.
Yeah.
And if you go to page 3, on lines 10 and 11, if you read that, promise performance that the person does not intend to perform or no. So I mean, so what's which?
What I'm talking about is on line 7, page 1. I think knowingly intend is just redundant. Like, you can't intend without knowing. So you can either say knowingly enters into a contract with intent to defraud, or separate them out somehow. That works for me, and that's the way the actual page 2 and 3 work, is knowingly, and then later on, as a different way of saying the same thing, intends to do. So it's just using synonyms.
I think that is right. I think another way of responding to your question, Senator Norris, is that intent to defraud is actually only one of several possible ways that you can violate the statute. So if you look on page 3, where you have subdivisions 1, 2, 3, and 4. 1, 2, 3, and 4 are each like separate, independent, possible ways to violate the statute. We've really been focused on talking about 1, because that is where these trial court decisions have focused. That is what the prosecutors were bringing cases under. That's intent to defraud, right? That's where we see the intent language. If a person knowingly promises performance that the person does not intend to perform or knows will not be performed in whole or in part, that really is intent to defraud. 2, 3, and 4 on lines 12, 14, and 17 are kind of alternative ways that you could violate the statute. There are also versions of fraud, right? Like a misrepresentation of a material fact, using an unfair or deceptive act. Those all still sound in fraud, but they're not precisely the same as an intent to defraud. But for all of them, the requirement is that you have to have the state of mind entering into the contract that you either intend not to perform it in part, or that you know you are making a statement about a material fact that is false, or that you know you are using some kind of deceptive act to get the person to agree to the contract.
Senator Wilson.
So I have a couple questions. One, and I can't remember who it was that spoke to this. It might have been the Attorney General's office, but I don't want to put words in their mouth if it wasn't them. It sort of spoke to the idea that if somewhere along the way, someone makes the intentional decision to not complete the work, that should also be considered. And my understanding is under the current language, it wouldn't be. Is there a way to loop that in?
So
1A on 3, right?
the removed 1A, correct?
Right.
So that's the this is the constitutional challenge that the trial court decisions have been talking about. That what we heard from Kim McManus was that in many cases, the contractor does not intend to not complete the contract at the start, but at some point along the way, they realize they won't be able to complete the contract and they don't do it. The challenge is that if you do not require an intent to defraud or some fraudulent mindset at the start of the contract, what you're effectively doing is criminalizing breach of a labor contract. So you're saying that regardless of what you intend to do in entering into the contract, you're not completing a labor contract and you're criminalizing your act of not completing it. And that's the 13th Amendment challenge according to these trial court decisions.
Right, and I guess what I was hearing is that there's a difference between not being able to complete it because you went bankrupt, because your office burned down, versus deciding along the way, like, actually, I can make more money if I just sit here and don't, you know what I mean? And I don't know if there's a way, maybe there isn't a way to thread that needle.
I think we haven't heard a way to thread that needle. That's the challenge.
Okay, and then my other question, is around, as I'm reading through this, sort of the intent to broaden a way that is perhaps like using subpar materials or, and I don't know if there's a way to address that or using known unsafe materials, to cut corners and save money.
If if a contractor intended to do that from the beginning and a prosecutor could point to evidence that suggested that was the case, like they had already purchased the substandard material when they went to the contract, for example, then I think it would be covered by one of the divisions in existing law. I think you'd have to hear from a witness who prosecutes these cases to talk more about the kinds of cases they generally run into, and if that's the kind of thing they feel like they can win, that they do prosecute, they run into. I'm not sure about those.
Anything else? Go ahead.
I think not much further from me unless the committee wanted to kind of run through the constitutional issue again. Just to kind of recap the key changes in this bill on pages 2 and 3, adding knowingly on page 2, line 18. When the person knowingly enters a contract, it's clarifying that this fraudulent mindset has to be there from the time of entering into the contract. And then on page 3, this is removing the stricken language on lines 3 through 10, is removing what was added in 2015, which the trial court decisions have read as criminalizing breach of a labor contract in a way that creates the 13th Amendment issue, and returns to this focus on an intent to defraud from the time of contract, promises performance that the person does not intend to perform or knows will not be performed or in part. So the bill returns to the 2015 language and adding knowingly, removing what was 1A and adding this language. The only difference would be it does not add back in that presumption that if someone doesn't complete the contract, a jury can presume they never intended to complete it, because that is part of what the trial court decisions found to be part of the 13th Amendment issue.
Senator Bruce.
To go to Senator Kovsky's point, on page 3, stricken language taken out, we will still have line 14 and line 12, those 2 and 3. So the situation where they use substandard materials seems like could fall under 2. They misrepresent a material fact about what they're using in the construction. If that doesn't wholly cover it, it seems like unfair or deceptive practice in 3 is built around getting them to enter into the contract. But could that be broadened so that it was in the furtherance of the contract?
So it's an interesting question. I think the language of 3 includes using an unfair or deceptive act or practice to modify the terms of the original contract, which I think captures kind of the idea that if you are changing the terms of the contract, you're in essence creating a new contract. So if in doing that, you misrepresent something, then even under the current statute, that would be something you could pursue. I think the challenge is that if you promise to use good materials in the contract and then you just don't use good materials, unless a prosecutor could show that the person knew at the time that they were never going to use good materials,
Right.
That's just breach of contract. That's not fraud. And that's the real tension, is that like when you're criminalizing not following through on the contract, because it's a labor contract, you have the 13th Amendment issue. But if you're focused on fraud in entering into the contract or making the contract or eventually modifying the contract.
So this wouldn't prevent maybe I have this wrong, but this wouldn't prevent the AG's office from pursuing, consumer fraud charges.
My understanding is that no, it would not.
Okay.
But I would want the AG's office to confirm that.
So this is just purely, revising down the criminal section in line with these code. Okay. All right, so people would have other remedies. Right.
That's my understanding,
Okay, great.
that there are still civil remedies. The challenge is with, you have civil breach of contract remedies. I think we just heard from, or the committee heard from, some witnesses that can be slow or not as big deal as.
So under this new existing proposal, the Defender General, a testimony that he doesn't oppose this. So that would mean to me that it's going to be very difficult for the state's attorney's office to prove intent on this particular situation as it's written right here.
I think proving intent to defraud is almost always circumstantial, right? The committee heard testimony that unless you happen upon a diary of someone saying, I'm intending never to do this, it's proved based on points out evidence. And I think the McManus testified that can be a challenge. The kind of tension is that requirement that is challenging is also the requirement that has to be in a statute for it to be constitutional, according to these trial court decisions. And as I think Senator Rossi's question flagged, we haven't seen a suggestion of language that would thread the needle, that would kind of address what makes these cases hard to prosecute while also going within the constitutional limits for these trial court decisions.
So I have one more question. In reference to, we took testimony where we talked about, well, the witness said that part of the fees were supposedly for a specialized window or whatever else. 6 weeks later, they went and checked with the whatever firm they ordered it from, and they hadn't even ordered it yet. So we're looking at fraud there, a breach of contract, or neither. After 6 weeks, the individual never ordered this special window, and then they found this.
So I think that's one of the kinds of facts that a prosecutor could point to in trying to say, based on all of the conduct of this contractor, even in entering into the contract, they never intended to follow through. I think the one Supreme Court case, recent one that I'm aware of, still, it was 2011. The fact pattern there, the contractor basically like kept asking for advances for various things and kept not doing what the advances were supposed to be for. And a jury found that indicated he never intended to complete the contract in part, at least. And he was convicted. The Supreme Court decision said, yeah, that kind of evidence is sufficient to find an intent to defraud. They paid the conviction for other reasons, but those are the kinds of facts that a prosecutor could point to try to explain to a jury that the person never intended to complete the contract. But pointing to it alone, it wouldn't be enough. It would all have to be towards in furtherance of showing that the person did not intend to complete the contract at the start of the contract. Under the statute, it wouldn't be relevant to show that they just didn't do what they said they'd do under the contract. That's not the key element.
Thank you. Any further questions from the committee? Well, I guess we get to the point now where it doesn't appear as though we have made any changes or significant changes on the bills that was entered presently. I thought Senator Wilson had some ideas on this, so please go ahead.
I did. So one of the things we heard from Kim McManus is that it would make sense to sort of move this fully into the purview of the Attorney General's office to let them sort of decide where it would best go. And I think I agree. And so if the committee supports it, I would certainly support adding language that does that into this bill.
When you say move it into, this is
So contractor fraud is a whole, what sort of happens now when they were testifying is that there's sort of a question, does it go to the state attorney, does it go to the attorney general? The attorney general has sort of oversight and Tim McMahon has testified that it might make sense to sort of fully move this into their purview to decide where to put it out to just be a little more clear. That these cases originate in the attorney general's office. And their team of civil and criminal litigators would then decide what to do with them.
But correct me if I'm wrong, if it's a criminal statute, we don't say that the state's attorney can,
The,
prosecute. Or do we?
so the AG's office and district attorney's offices would have concurrent jurisdiction. They both have jurisdiction. I'm not aware, but that doesn't mean there is not somewhere else where we say for a statute, the AG's office has exclusive jurisdiction.
Right.
I'm not sure what language would look short of that. I'm not sure what language would look like.
Because we're just talking about the criminal statute.
Yeah, when I asked Kim
Yeah.
McMahon, I said if that would be more sensical and sort of eliminate some of the confusion, and I recall the testimony being like, yeah, that would make sense.
I'm just confused though. How would we move a criminal statute so that only the AG could prosecute it?
I think, I suspect, and I'm happy to look into this further if the committee is interested in pursuing this. There is another statutory provision that I think lays out the jurisdiction of the Attorney General's office, and that is probably the place to make a change of that nature. There might also be something here to say, like, these offenses, prosecution of these offenses shall be in the exclusive jurisdiction of the Attorney General or something like that.
I mean,
But it really would be making a change to,
the fraud division that, that's breaking civil charges. Yes. So I don't know how it would help things if we limit the number of people who could bring the charges. Seems like then you run into backlog problems with not having enough people. As it would stand now, you could have the AG or a state's attorney bring the case, right?
yes, I think that's a policy
Yeah.
question. And I am not confident on the numbers of people doing these things in both
I wasn't clear for
offices.
Kim McMahon's testimony.
I wonder, so a couple things. It is my understanding we have sole jurisdiction to tell the Attorney General what they do and what they don't do. But I wonder, given that we've heard from the Attorney General saying this might make sense, if it might also make sense to hear from the Department of State Attorneys and Sheriffs, if it makes
Sure.
sense to them as well. You know, those are the two entities that are at play here. And so maybe we should hear from them and hear their thoughts on whether that would make sense to them before we take any next steps. Like I said, I just heard that from the Attorney General, and so I'm like, well, you know, that makes sense to me, given that they're sort of the oversight mechanism, they're the ones doing consumer protection. But I think it would make sense to hear from the Department of State's Attorneys and Sheriffs on that point.
And just in case I'm misremembering, was it McManus who suggested that? So it would be hearing from the AG's office.
Oh. Right, but I also think it might make sense to hear from 10 leaders too.
Certainly.
I'm not opposed to that idea. I just, my thought process here is, does it slow the process down once again, as far as this case referred to the AG's office, and now get 6 to 8 week delay. I think Todd testified when he was here that they do have this counter jurisdiction, but basically the only thing they come involved in with is homicide investigation and prosecution of such, and they're really somewhat overwhelmed presently. So, but I'm not opposed to the idea. Just want to make sure it doesn't slow this down for the alleged victims.
Yeah, absolutely. Well, and I think about the caseloads, like when I think about our state's attorneys with, you know, an average of 400. And we've heard from them too, that, you know, they're not prioritizing contractor fraud, they're prioritizing, you know, the big violent stuff, whereas I am under the understanding that the Attorney General office has a much smaller caseload. So I just like to explore it.
Yeah, I'm just wondering, right now, it's in their discretion whether to do it or not, whether to bring charges or not. They can, they don't have to. Same with the attorney general, can, but doesn't have to. So I'm wondering why we would make it so that only the attorney general. Anyway, we can ask those questions of those folks.
I think they asked where the case goes.
Right, I just don't remember ever us, are there other places where we do that, where we?
I'm not aware, but that does not mean there is not. So if as the committee, if the committee wants to continue to explore this and look into that particular question.
Any further comments, suggestions, questions? So I guess we're not quite done with S1 agency. We'll set up, reach out to the agent's office along with the SAS and there's a question. So if you're off and running on this, Hillary, I'm assuming you're gonna come back on this same building in the next time.
Sure will. You're now stuck with me on this one. So.
Okay, thank you. So there's no more questions on this. Our next witness is 10:30, so we'll be back here about 25 after 10.